is State versus Shank. We are just about 5 minutes early. Is there any reason we can't proceed? Are you expecting anyone or anything?
No, not expecting anyone, but you can proceed if it's the pleasure of the court.
That would be fine with us. We'll go ahead and hear, and the appellant will have 15 with up to 5 minutes for rebuttal, and the appellee will have 15 minutes.
Thank you.
Thank you. Just let me know if you want to save some time.
Good morning, Your Honors.
Morning.
Attorney Michael Chiselka on behalf of the appellant Patrick Shank. May it please the court, I'd like to reserve 5 minutes of my time for rebuttal.
Thank you.
This case, to me, is ironic insofar as, in a lot of cases that come forward on appeal, the appellant would ask the court to look at minutiae, little details as far as either testimony or evidence, and hope that there is enough small pieces that can be cobbled together to make a valid argument. In this case, I believe the opposite is true. I believe it's the big picture problems with this case that warrant Mr. Shank getting another better and fair trial for the first time in this matter. I think the fact that it proceeded as a bench trial when defense knew that the judge had confided the fact that he was a friend of the grandfather, when the judge presided over the previous case, merited a fresh and independent and separate set of eyes. The judge never ruled on a motion for new venue, just proceeded, and they continued to try this to the bench. I think the defense counsel, the defense team, between allowing this to be a bench trial before trying it in front of the same judge and bringing no witnesses that had the authority and ability to contravene what was being said by the alleged victim in this case.
Let me just ask a question. Are we going to find in the record a statement by the judge regarding his relationship with someone's grandfather, or was that in a previous case?
I think that was in the previous case. I would make that an error on part of my argument of ineffective assistance.
I see.
Knowing that moving forward and taking it out of the province of a jury, knowing that. It's kind of like the snowball in Bullwinkle and Rocky. It starts off small and rolls down the hill and just gets bigger and bigger. I do believe in the record there's a sidebar where the photographic evidence that also would have contravened the alleged victim's testimony, the judge refused to even take a look at. I don't know how you do not make any hay out of your biggest argument being that if this was something that supposedly happened over hundreds of times, that a horrible disfiguring scar is something that was never known, mentioned, or part of the testimony. And the family able to say that there are upwards of 100 allegations of incidents that happened, when through the entire timeline there is opportunity along the way where all the members are together, no behaviors complained of, nobody said, noticed any difference in behavior or fear or what you would expect if something like this had happened once and you were in the presence of everybody that either participated in this, supported this. I'm tongue-tied now over the fact that I haven't even gotten to the fact that my argument for putting the victim or the Mr. Shank on the stand, to give him an opportunity to have that taken away from him. I know that the standard is, well, the results have been different.
Well, not only that, I'm not even sure where we get to, whether the results would be different. The preliminary question is, what's in the record to support the allegation that he was denied the opportunity to testify?
I attribute that to ineffective assistance.
Well, so it may be that that is an issue that would be more appropriate for collateral attack, for post-conviction relief.
Understood.
Because if it's not in the record,
Understood.
you can't consider it.
But, I mean, you fail to see in that situation, you know, I can understand an argument when you have a lawyer that says, well, I didn't want to put my client up in front of a jury. But this is a bench trial. There's absolutely no reason to not do everything that's possible to give your client a fair trial. I just don't see how any of this added up to. From the beginning, from the earlier arguments I made in my brief about how the fact that the prosecution admitted the fact that they didn't even investigate or talk to anybody in the Coe family. The inconsistencies with regarding the alleged victim's testimony throughout the course of the trial. The fact that, well, again, there's other evidence and new evidence, and I know there's proper and different ways to address those. It's hard when all of this comes together. But I just fail to see how Mr. Shank got a fair trial to start with. I don't know how any of this should have been. And with regard to the relationship, and you properly asked whether that's a matter for a collateral or post-conviction attack. The sad thing about this is when this is a bench trial, I believe the judge had the affirmative duty of making this clear to start with.
Making what clear?
That there was a relationship, that he may have known somebody that properly, should have recused from the case. Those are things that I believe that, especially in a bench trial situation, the judge has an affirmative duty that should have preempted any and all discussion about how it was treated on the record by defense counsel. Failure to view the evidence that is the strongest evidence regarding credibility of the alleged victim's testimony. And then I know that this court always comes prepared, and I know you've read through the tenor and tone of some of the exchanges between the bench and defense counsel regarding things like questions, objections. Trial is only a matter of a couple of days. It's not like they were at the end of a month's worth of contentious litigation. This is a judge hearing years worth of testimony basically just from the alleged victim in this case. So I can't read that record and feel that Mr. Shank got a fair trial. That's the argument that's made throughout the brief, from the investigation through the verdict. And also the other evidence argument, with regard to that being brought in too. Again, I refer you back to the snowball analogy. That's other evidence that I think the judge erred in ruling that testimony came in. And at the end of the day, plain and simple, I believe that the next fair trial that Mr. Shank would receive in this matter would be his first fair trial. And absent a question, I'll save and reserve the balance of my time.
Okay. Thank you.
May it please the court, my name is James Price. I'm an assistant prosecuting attorney for Medina County, and I'm representing the state in As counsel said, they focused on credibility of the victim, in this case, AM, and I think all that the state can say in that regard is that the trial court heard testimony from AM, from EB and RA, heard testimony from the appellant's wife, Darla Shank, heard testimony from Brian Clubb, and the trial court determined that the victim's testimony was sufficiently cogent and believable to have led to his decision in the case. That he didn't have a problem, at least not to the extent that the appellant's raising, with the victim's credibility. Now, there may be problems with credibility on both sides, and whether their statements are 100% credible, but that's where the trier of fact comes in to make a decision regarding those competing witnesses. I think one of the things that's important to point out is, the trial court's looking at the victim and saying, well, what's her incentive to come in here and lie to the court, to raise these issues? And I don't think there was any indication during trial that there was sufficient motivation, whatever it could be, for the victim to come forward unless these things actually happened to her. On the other hand, the witnesses for the defendant, they have an interest. Family members mostly are friends. So I think the trial court made the right decision in this case, and I think that in terms of credibility, I think the credibility fell to the victim rather than against her. So in terms of manifest weight, I believe that there was sufficient evidence, all the elements of these offenses to have convicted the defendant. Of course, when it comes to the sufficiency of the evidence argument, the credibility of the victim's testimony or the defendant's witness's testimony is no longer a factor. So I believe that in terms of sufficiency, just have to determine whether the trial court felt there was sufficient evidence of all the elements in the offenses that the state charged the defendant with. And I think if you listen to the victim's testimony, what occurred, that Mr. Shank played with alcohol. She was 12 years old when it started, and had sexual intercourse with her. I think that's pretty much the sum and substance of that argument. I think the defendant, also the appellant, said something about whether or not AM was actually substantially impaired during these incidents. And from what I understand, for a child or someone not accustomed to using alcohol, substantial impairment can occur with, one drink. It's subjective. It's difficult to ascertain. But we can say in this case that if we believe the witness, that Mr. Shank gave AM alcohol and then had sexual intercourse with her. So I think we can assume from the fact that she's a minor, she's a child basically, and she's drinking alcohol, that she was impaired. I don't know how thoroughly this was addressed in the briefs, but as far as the appellant's scars that are on his body, I don't think that anybody argued this, but I think it's common knowledge that people who experience traumatic events suppress those memories. And many times we don't remember details from those things. We may remember globally what happened, but the details tend to fade away from us with time. Other than that, I don't know what else to say about the photographs that they mentioned, or that they're dispositive of anything. I apologize. With respect to the incident, the single incident that is said to have occurred in Cuyahoga County, and whether that necessitated a change in venue, I think that the law is clear that it doesn't. It's a continuing course of criminal conduct that started in Medina County. Whether it be necessary or efficient to have another hearing in Cuyahoga County on that single incident, when it was in a continuing course of criminal conduct, I think is dubious. Let's see. Sorry. The evidence of other acts that I wanted to address that, because I think the court made it clear that it did establish a common plan or scheme or modus operandi. And I think it's also important to point out that a trial court or a judge is less susceptible to misunderstanding that evidence than a jury would have been.
What about the issue of identity of the victim, whether the identity of the perpetrator, and the need that that be an issue?
Whether it should have been an issue? I believe that the Ohio Supreme Court, well, I know the Ohio Supreme Court has said that it's always an issue, because I argued the case down there in Tate. But in this case, I think it was an ancillary issue, just a technical issue, rather than a real question whether or not Mr. Shank was the person about whom the witnesses were testifying. So, from my understanding of the case, I believe that the witness testimony, I guess, from ED and RA, was to show that Mr. Shank had a propensity had a common plan or scheme, that it was young girls that he was interested in, that he would ply them with alcohol, and then didn't have sexual relationships with them. And I believe that was all that the court was looking at, was the modus operandi. As far as ineffective assistance of counsel, I know that there are a number of points there. As the court knows, counsel is presumed competent. I don't see anywhere in the briefs where they pointed to an area where defense counsel was deficient. I think the decision whether or not Mr. Shank should testify, we don't know what happened behind the scenes there, what they discussed. I see good reason for defense counsel to advise him not to testify. Don't want to expose him to cross-examination. We don't know what they knew that the prosecution may have wanted to delve into more closely. So I think, from my perspective, that was reasonable and effective assistance to advise him not to testify. If that's truly what happened, he may have just not wanted to testify, we don't know. As far as asking for a change of venue, again, I think early in the proceedings, there was a conversation about whether the judge should recuse himself. And I believe that they resolved that. There's not a lot on the record as what the reasons for their decision to go forward with this judge was. But what we do know is that they said, we're okay, Judge, let's go forward. So that's really all we know in that respect. And the change of venue, again, to move one hearing to Cuyahoga County to adjudicate an act that was part of the continuing course of criminal conduct. I think that the trial court could have reasonably found that that was not necessary or ill-advised. I believe I've covered all the issues that were in the appellant's brief. If the court doesn't have any questions, I would just ask that you overrule the defendant's assignments of error, or the appellant's assignments of error, and affirm the trial court's decision.
Thank you, counsel. You still have 5 minutes.
Thank you, Your Honor. All I'd like to remind everybody about and close with is the fact that these occurrences allegedly happened in 2003 and 2004. Over 100 times when the alleged victim was 13 and maybe 14 years old. And she lived across the street. And for being plied with alcohol or pills, never was any behavior discovered by family, by friends. And then if this stops in 2004, and she doesn't report it for 8 more years, during the course of those 8 years, she stayed friends with everybody and confided in the adults, the other teenagers, the other children, and never once. Now and we know that bad things happen to children in this world, and I'm not making light of, but I've never seen a situation or a case where, absent the power and abuse or proximity of that being a family member, I can't help but say that once again, he got no defense whatsoever from this supposed team of trial attorneys, because none of the other people involved, the co-family, the adults, her mom, everybody that should have been called. It's not what's in the record that's deficient here, it's what's not in the record. 100 supposed incidences of this kind of abuse involving drugs and pills and curfew, and where were you? You were a 12, 13-year-old girl, and never once, Mom, something's bothering me. Mom, I don't want to go to that man's house. again, kids have the ability in this day and age to be too knowledgeable about what's on the internet and what they have access to at an early age. Don't forget, by the time she brought these allegations forward, she was older and sexually active herself. So the reflections
What
of
does
it.
that have to do with anything?
Well, my point is to bring and make up the allegations. She never told anybody in 13 or in 2003, 4, and 5. There are no descriptions of it.
Like that.
Yeah, no, I understand, but again, like I said, this all boils down to what kind of defense. Read the trial transcript as I did. This case was never even defended. He never got an opportunity to mount a credible defense. With all of what was there, the family members testified that she didn't babysit. The credibility, if you just went to the fact that, well, I babysat those years, she was 13. She got paid twice to babysit, and it was after she was older. 6 people testified that she never was the family babysitter.
Well,
And the person from the band that testified said there was never any appropriate behavior. And
He
not only
said
that,
he did not observe it.
right, this is 5 years after supposedly she'd been raped 100 times by this man. When
And
everybody,
there were other young girls who
Yeah.
also testified as to that same behavior. So the question arises when you say that, he was advised not to testify. If, as the judge gave credibility, not only to the victim of the assault, but also to the other witnesses, if they are to be believed, then there may have been a good reason why counsel did not wish to have your client testify, and why he may not have wanted to testify, believing that some of these
Understood.
factors would come out.
and again, my hands are tied because we're confined to the 4 corners of the record.
As are we.
But again, as I said, this isn't a case where we're looking at the minutia. It's step back and look at the transcript and see how this doesn't pass the muster of a well-defended trial case at all. Like I said, the last thing I'll say is the next fair trial he gets will be the first one. Thank you.
Thank you, Ken. Thank you both for your presentations to the court. The court will have a written opinion that will be issued to both sides, sent to you. And we also release on our website as well as the Supreme Court website. So you can look there for an electronic version. Thank you for everybody for attending, and the court will be adjourned